Buenos días. Good morning to those of you who are here again in a physical attendance to the conference, and of course, good morning to those of you who are following us through the streaming broadcast of this conference. I have the pleasure and the honor to introduce you my friends, could I say, after the years, Iain MacNeil and Irene-Marié Esser. Both of them are professors at Glasgow University. Iain was a former dean of the Law School of Glasgow University. He holds the Stone Chair of Commercial Law, and Irene-Marié is professor of Corporate Law and Governance. They have been working together for years, publishing papers in a fruitful cooperation, and for this reason, they are going to give, not simultaneously, but to give us this first lecture in this, again, joint venture, scientific joint venture. You have a brief CV or bio in the brochure, then I won't steal you time, and I give you the floor, Iain and Irene, and you can manage your time. And afterwards, we will have a short debate. Thank you very much. You have the floor.
Thank you very much, Alfonso. And let me say, it's a real pleasure to be here. I think previously we appeared via Zoom in some of your events, so it really is much nicer to come here in person, and especially to share such a nice dinner such as last evening, and meet more of the participants in the project. So as Alfonso mentioned, what we present today is a combination of various papers that we have published in recent years. And what we're really focused on is what we're calling an entity ESG model, and especially attempting to explain what this means for disclosure and particularly stakeholder engagement. I think we can begin by saying that ESG, and I think most of you are familiar with this terminology, environmental, social, and governance elements of corporate governance. ESG and the role of stakeholders have become key focal points in current debates on corporate governance. In today's presentation, we introduce our recent research and we link them to the entity model of ESG that we have recently proposed. ESG and CSR, corporate social responsibility, are often treated as similar or equivalent, but their history and focus differ. ESG developed with a financial focus in the context of institutional investment, whereas CSR developed more in the corporate context as a matter for board decision-making and with an explicit ethical focus. And I think it's true to say that historically, the tradition of CSR is older than ESG. ESG is a relative newcomer, and CSR is a much more established traditional concept. So today we examine three mechanisms that are closely linked to these issues. The first is non-financial reporting, which has grown in significance in recent years. Related to that is the issue of stakeholder engagement, and by that we mean engagement with those stakeholders other than the shareholders in the company, which have been the traditional focus of attention in corporate governance. And linked to both of these elements is what we refer to as the entity ESG model, which is a little bit different to what we would describe as the dominant model right now, which focuses on the financial aspects and on the role of institutional investors. So we could begin by explaining a little bit more about the relationship of sustainability with CSR and ESG. And of course, here we are presuming, correctly I think, that sustainability has become probably the key concern of corporate governance in recent years, or at least the key new concern in terms of integrating sustainability into governance structures. So we take the view, if we consider sustainability first, so sustainability we would see as being concerned especially with externalities and stakeholders. And by that we mean that sustainability attempts to eliminate externalities, which we would classify, for example, the classic example would be environmental pollution. Those costs which are externalized by companies instead of being borne by them themselves. So we have sustainability, and sitting below it, we've got the two different concepts of CSR and ESG. Now, CSR, as the traditional concept, focused much more on the ethical responsibility of the company, its directors, and accountability in board decision-making for that ethical decision-making. We could contrast that with ESG. So ESG represented a change in the historical evolution, because ESG shifted the focus onto a risk management perspective. ESG evolved as a technique to mitigate and potentially eliminate risk in investment portfolio construction and engagement with companies. So in that sense, the focus of ESG represented a break with the ethical tradition of CSR. So in terms of the relationship between the three, what we say is that we have here an example of a trilemma. So a trilemma is where we have three elements, but really you can only choose two together. Only two will work together. So what we envisage really is that when it comes to sustainability, you have a hard choice. You can either go down the road of CSR or you can go down the road of ESG. You can't do both at the same time. You can try, and some people would claim that this is possible. But I think our view certainly is that that is a difficult attempt. Linking that a little bit more to the timeline or the evolution that I mentioned, we could say that the evolution moved from the ethical dimension of CSR to the focus on sustainability, which in many ways, and those of us who've been around a bit longer would remember things like the Brundtland Report back in the 80s, which was from the UN and focused on green issues and the protection of the environment. So the economic focus on sustainability brought these ideas about externalities particularly, and how we might be able to solve the issue of externalities. As I mentioned, ESG emerged later as a technique for managing risk, and its focus was really on improving long-term returns for investors. It wasn't as directly focused on internalizing externalities as the sustainability or the green movement from the 70s and 80s had been. So ESG is evolving particularly in the 90s, the late 90s, and coming into the early 2000s. And for example, by 2005, we see the UN Principles for Responsible Investment. And that, I think, would be, I would characterize that as the key moment of the early evolution of ESG, and things that have taken place later have largely built on that early stage of evolution. And I could just throw in, we don't go into it here, but we have another paper which focuses on that early stage of evolution to try to explain why did this happen. From the point of view of history, why did this happen? And we explain this in terms of the issue of legal uncertainty. We're not going to go into that today, but it is an interesting idea that actually legal uncertainty may have caused the evolution of ESG in the form that we see it today. So switching back more to the focus for today, we could say, what are the key attributes of CSR and ESG? And this is really explaining what are the primary differences between them. Now, I mentioned mostly the focus, the channel, and the implementation. So I mentioned the focus already, and you can see the summary here representing what I already said. Focusing more on the channel. In other words, what is the channel or the conduit for the CSR and ESG ideas to be developed? And so for CSR, this was taking place in the corporate entities. The early ideas about CSR were directly addressed to companies, not so much to investors. These ideas were seen as being relevant for action in the operational aspects of companies. Whereas with ESG, that focus on, if you like, the operational elements, or you could say even the real world dimension, was not present. It was about how would investors construct portfolios to mitigate risk. And the risks were, for example, we could say the risk of, we talk now about stranded assets, for example, oil and gas. Those assets have been greatly devalued over the past 10 years. So, the issue would be how are those risks mitigated? And then thirdly, implementation. What is the method of implementation of each technique? So for CSR, the implementation method is board decision making. Again, this is focused on the operational dimension. With ESG, we don't find board decision making as being the primary focus of attention. It is portfolio selection and engagement. And by engagement, we would mean, in more modern terms, we could say stewardship. So stewardship has become a word which, 20 years ago, people didn't talk very much about stewardship. Now they do. There are stewardship codes in many different countries. It's spread all over the world. And, stewardship is seen as an important duty of the institutional investors with regard to their duties to the underlying investors. So returning to the first mechanism that I mentioned, we turn now to non-financial reporting. In its origins, non-financial reporting seems closer to CSR than to ESG, because non-financial reporting by companies is focused on the operational dimension, and through that is linked very closely with board decision making. And while CSR and ESG have a common interest in non-financial reporting, they share this interest, and it's an interest in information that is relevant for stakeholders, in other words, non-shareholder stakeholders, even if it's not financially material. That's really the key dimension of non-financial reporting, that there are important issues to report on, for example, linked to sustainability, which may not necessarily, but they often do, have financial significance too. So in the EU, we saw these ideas developed by the Non-Financial Reporting Directive in 2014. It established important principles for large companies to report sustainability information. And it introduced, although the idea was around already, it introduced in the legislative domain the concept of double materiality, meaning companies have to report on sustainability issues that affect their business, but also their impact, the company's impact on the outside world and the environment. Now, of course, more recently, the UK is not part of the EU initiatives, but it still remains an important player globally in terms of the development of this concept. And what we've seen more recently is an emphasis on what is termed TCFD reporting, which is the TCFD is the Task Force on Climate-Related Financial Reporting, developed by the FSB originally, the Global Financial Stability Board. And so the UK has actually in some ways moved ahead of the EU on this dimension because we now have TCFD reporting for listed companies in the EU, and quite soon we will have it for all substantial companies from 2022. And that will require them to expand their non-financial reporting and develop plans for the identification and management of climate-related risks. Now, linking that to the broader ESG perspective, this means the focus on the UK in recent trends, developments, is on the E, the environmental aspect. And we could contrast that, for example, with the EU, where there's a stronger focus on the S, the social dimension. So as you made note, the social taxonomy is under development in the EU, not quite ready yet. But I think it is indicative of a stronger interest in the EU in the social dimension. The G, of course, we could say historically, as far as the G is concerned, the UK has been a leader. The UK Corporate Governance Code has been a global model, and we've written quite extensively about how that has occurred. So I'm going to finish up a little bit briefly by just talking about some of our research. We've done some empirical research on financial reporting to see how it works. Does it work well? And we've done this two-stage study. So we've looked at compliance by FTSE 100 companies in the UK with non-financial reporting. And bear in mind, when we talk about FTSE 100, this is a very international set of companies. It's not just a matter of the UK. The FTSE 100 is a very global index. So stage one was the empirical analysis. Stage two was following the empirical analysis, developing the empirical analysis through qualitative research with stakeholders. And I mean, what we found from this was that actually there was strong evidence of good compliance with the non-financial reporting requirements. Actually, very few instances of poor compliance. Where we did find relatively weaker compliance was in respect of the requirements that the role and objective of what is called the strategic report in the UK, which is the non-financial reporting obligation. The role and objective of the strategic report was not very well clarified. And particularly, it was not linked very clearly with the basic company law duties of directors. So that was a weaker element of the system. And similarly, what is called the forward-looking orientation. In other words, indicating what are the future plans, and especially, you might say, the future ESG-linked elements of the plans of the company. Those elements were relatively weaker. But in the main, the main conclusion we find is that there is good compliance. And one of the reasons we considered that this might be the case was that actually what we termed super compliance was maybe a strategy to preempt regulation. In other words, this looks a little bit like the market suspecting the government intends to regulate more, but actually taking the action before it happens. In other words, the idea that it may be better to move voluntarily and control the process rather than to be faced with more formal regulatory intervention. So I would just sort of round up by saying that as far as stage 2 was concerned, the feedback that we had from the stakeholders was that even though we found strong compliance, they found that non-financial reporting didn't help them really that much. It didn't help them to understand how to engage with the organizations to make their views influential in board decision making. That bit was missing. And that's related to the point that I made that the non-financial reporting does not really clarify, or it doesn't link very clearly to the duties of the directors. And of course, the duties of directors, at least in the UK system, they require the interests of the stakeholders to be integrated into decision making, and that's something which we would come on to now in the second part.
Thank you very much. I will now deal with the second mechanism mentioned at the start of the presentation to help to ensure better sustainable companies. So we've dealt with non-financial reporting as the first mechanism, and the second one that I will focus on now is stakeholder engagement. And in the UK, stakeholder engagement is in a sense regulated through hard law as well as soft law. So with hard law, the main section to refer to in this context is section 172 in our Companies Act that I'm sure many of you are aware of, that sort of embeds what is called the enlightened shareholder value model into company law. So according to section 172, directors have a duty to promote the success of the company over the long term for the benefit of the shareholders as a whole. So the focus is still very much on shareholder primacy, but also have regard to a range of other key stakeholders and interests. So as I said, this is in line with the enlightened shareholder value approach. Stakeholder interests are therefore considered, but in the end, it is still what is best for the shareholders, in other words, shareholder primacy. And it's maybe worthwhile to mention that the UK is neutral on the specific board structure, but the prevailing model is, of course, the unitary board structure. Then to just briefly refer to soft law, in other words, the 2018 Corporate Governance Code, where there is an increased focus on stakeholder engagement, and provision 5 is specifically relevant in this regard, which is a new provision in the 2018 Corporate Governance Code. It was not part of the previous codes. So we've also done some empirical research with regards to provision 5, and I will talk about that a little bit later, but perhaps just to say that under provision 5, there is a requirement on companies to adopt one of 3 options for workforce engagement as specified in that provision. So the focus in provision 5, although it relates to stakeholder engagement, the focus is very much on the workforce and not just employees, but the workforce, in other words, a broader term. And this is an important development in terms of integrating stakeholder interests into board decision-making, resulting potentially in better stakeholder engagement. So at a high level, the key provision providing for integration of stakeholder interests, in other words, section 172 in the Companies Act, is focused on outcome. It specifies that the board should consider the relevant stakeholder interests. But the move to provision 5 indicates a shift to a more explicit process for the integration of a limited set of stakeholder interests and a move away from the reliance on disclosure as the only or the primary regulatory technique in this context. So as I've just mentioned, Provision 5, the soft law element of stakeholder engagement in the UK, and in Provision 5, provision is made for various options that a company can opt for. So they can use one or a combination of the following methods. They can either have a director appointed from the workforce, a formal workforce advisory panel, or a designated non-executive director. And as I mentioned before, there is no explicit participation tools for other stakeholders. So Provision 5 also works on a comply or explain basis. So you need to comply with that. In other words, you need to have one of these, you have to opt for one of these methods to ensure better engagement. But if you do not opt for one of those, you just need to explain it. So if the board has not chosen one or more of these methods, it should explain what alternative arrangements are in place and also why it considers that they are effective. So non-compliance, in other words, not following that is not non-compliance as long as you have a proper explanation. So a director appointed from the workforce will bring a workforce view to the boardroom. They will have the same duties and responsibilities as the other directors and ideally will be in a position to contribute to discussions on wider issues, and training and support will be critical to the successful implementation of this method. It is also underlined that while the director may engage with colleagues to understand the issues and challenges in particular parts of the business, their role is not solely to represent the views of the workforce. So as I said, we also did some empirical studies on compliance with Provision 5. We evaluated empirically how FTSE 100 companies implemented workforce participation tools in 2019, and that was the first year that the Corporate Governance Code of 2018 was in force. In other words, the first year that Provision 5 was in force. So our data was collected from the 2019 annual reports of these FTSE 100 companies. And as we evaluate the implementation of workforce participation tools, the corporate governance section of the annual report was the source of the data to ascertain the type of information disclosed by the companies. So on the slide, you will see some of the results or our findings indicating very good compliance. Out of 96 FTSE 100 companies for which the data on workforce participation tools was available, 95 introduced some form of workforce participation mechanism, so one of those three that I mentioned before. And option 3 on the previous slide, in other words, a designated non-executive director, was actually the most popular tool. There was not much evidence of how workforce interests are actually integrated into decision-making or strategy, nor is there much evidence that such considerations changed outcomes relative to what they would have been otherwise. So definite evidence on compliance, but less so with regards to actual integration of the interests. So all companies under review described in some way workforce engagement tools. They fulfilled the requirements, in other words, of Provision 5, but there's a lack of a consistent approach in implementing Provision 5 or in implementing the workforce engagement tools more generally, and that was our main conclusion. So just on the last bullet on that slide then, we characterize Provision 5 as moving beyond disclosure to regulate process. So in other words, that change left open the option for companies to continue or merge pre-existing workforce participation mechanisms with the options provided by Provision 5. So our research found considerable diversity in the solutions adopted by the companies, both among those complying with Provision 5 and those selecting alternative mechanisms, which is, of course, permitted under the comply or explain approach. In other words, it seems companies valued the flexibility evident in the regulation of process, albeit that the proliferation of mechanisms and limited disclosure on their integration into company decision-making protocols often made it difficult to understand how they actually work in practice. So then just briefly to link back to what Professor MacNeil said at the start when he explained the differences between CSR and ESG. In that context, we proposed what we call an entity model to try to ensure better sustainable companies, focusing on the corporate channel, as we said before, rather than the financial route, and focusing on a hybrid model as well, in other words, hard law as well as soft law with some voluntary action. On the slide, you will see there's sort of three parts to this model. Process on the one hand, dealing with due diligence, stakeholder board committees, and reporting or disclosure. Then you have the board, of course, and then also the substance side of this regulation, in the context specifically of the regulation of directors' duties, the link with ESG and remuneration, and also some suggestions on say on purpose. Now, in our full paper, we discuss all of these various elements, but of course, today we only focused on the two of those listed under process. We focus on stakeholder board committees or stakeholder engagement, as well as reporting and disclosure. So our entity model can, in other words, be explained by way of a table or a diagram that I will show on the next slide. And this is parallel to the introduction provided at the start on the key attributes of CSR and ESG that we mentioned at the beginning. And for today's purposes, it's only the first three that we really focus on, rather than, in other words, focus, channel, and implementation. So just briefly, so that I can still allow some time for questions as well. If you look at the slide, and apologies if it's a bit small, but maybe just to focus on the first three and give you a brief overview. So the first one, focus. Under the financial channel, it is all about portfolio risk and return, linked to metrics, benchmarks, and indices. The adjustment mechanism then to move over to our entity model is regulatory intervention focused on corporate responsibility, stakeholder integration, and remuneration. And obviously today the focus was on stakeholder integration. And then eventually have a model where you internalize externalities via stakeholder integration, link ESG to remuneration and sustainability strategy. When you talk about the channel, under the financial one, it's of course institutional investors and the investment chain. But then again, the adjustment mechanism being law reform, a duty of due diligence, and of course there's some ongoing work on that in the EU, a stakeholder committee, and then you can also make use of soft law through corporate governance codes in this context. And then you can also have more voluntary action through purpose provisions in the articles of the company, say on purpose provisions. And then eventually in the entity model, corporate entities will play the biggest role with regards to the channel through a board decision making. And then finally on implementation, there's integration into portfolio selection and engagement under the financial model. To adjust it, it's a broader scope beyond capital markets and focus on systematic risks, residual role for stewardship in this context as well. And then under the entity model, the operational focus in ESG implementation linked to real-world effects. So then, to conclude, today we tried to give you a broad overview of how we see and how we understand the relationship between sustainability, ESG, and CSR, and how we see those concepts developed over time and how we think they should work together. We focus on that to inform the elements of our proposed entity model. And today our focus was specifically on two mechanisms, part of this overall model being non-financial reporting and stakeholder integration. So the role of disclosure and engagement, in other words, in ensuring sustainable companies within the context of CSR and ESG. And as I said before, our model focusing on a hybrid model, so not just focusing on hard law, but having a mixture of hard law, soft law, and also voluntary action. So it would really be quite good and interesting to hear your views on this, to get any feedback or questions, perhaps to hear how this is dealt with in your respective domestic systems. And so any feedback or questions, we will be happy to answer that. I think we have just over 5 minutes left for that, so on time. Thank you so much.
Thank you. Thank you very much. We have here a nice opportunity to see, as you were commenting, in our different jurisdictions, how these matters are dealt or received. Then we have here people from Italy, Belgium, Germany. Then I wouldn't like to steal you the opportunity to raise any question, although I have some. Then, please, Dario, La Tela, Italy.
Okay, thank you.
Here the microphone is coming, another one, connected maybe to the streaming broadcast.
Hello. So thank you so much to Professor MacNeil and Professor Esser for the clear picture of this very interesting topic and proposal of model. Two short questions. The first one, probably to Professor MacNeil, is this: is there any space for freedom in choosing and making and doing business? From the perspective of the treaty and the functioning of the European Union, for example, it seems that we could imagine a kind of restriction to make business in a very wide way. This is the first question. The second question is probably for Professor Esser. What about the ownership of the corporation? In the sense that, from your words, I'm trying to understand what is the direction that the ownership, in a very pure sense, of the corporation is going to. Is the ownership of the shareholders, or is the ownership of a kind of wide community composed by shareholders, stakeholders, employees, and so on? Because we don't have to forget that the investment is driven by the shareholders, but the interests are entitled to a very wide community. Thank you.
Thank you very much for that question. It is actually linked to an aspect I was discussing with Alfonso just the other day, which is the idea of what is the purpose of corporate governance? What is it about? Because actually, you know, if you look at it nowadays, in terms of the developments that are taking place in the EU, the US, the UK, you would think really it is all about sustainability. This is almost the only issue that is discussed in various forms, including, for example, corporate purpose. And you know, that is directly linked into the question you raised. You know, what is the role of markets? What is the role of government? Now, my take on this is that, you know, what has been happening for the last, say, 10 years has been that markets have led developments. You know, so the early development of ESG is a market-led initiative. It is then, to my mind, adopted by governments in a regulatory sense, like regulatory intervention, as we see, and the EU is the leader, the global leader on regulatory intervention. But actually, what the regulatory intervention represents is the failure of governments to take the appropriate actions that are needed, for example, like carbon tax. So actually, the work of sustainability is being pushed down to corporate governance, I would say in an inappropriate fashion, because it is overwhelming the system. in a way that I don't think is entirely appropriate. It's being asked to do, corporate governance is being asked to do too much work in the global sense, in terms of its position in society as one mechanism in society. And I think that will ultimately lead to problems. And it is delaying more fundamental action by governments, which I think will prove to be costly in the long run.
Yes, thank you for that question. That's a very interesting question and a good point regarding sort of basically, in a sense, the differences in the shareholder primacy model versus the stakeholder model, and who should really benefit from directors' duties, in a sense. So, of course, at the moment, the shareholders aren't, in a legal sense, the true owners of the business, but shareholder primacy is the dominant model in a lot of jurisdictions, most jurisdictions, and definitely under Section 172, that is still the position in the UK. So, and I think we agree with that position, and that shareholder primacy should be the paramount view. However, we need to find alternative ways to protect other stakeholders and to ensure sustainability and sustainable companies. And it is quite difficult, as we can see with some of these suggestions, to find good and sufficient ways to protect stakeholders, but not to change underlying company law and to still realize that it's, like you say, ultimately the shareholders. So I think by changing directors' duties to actually change it to say that they need to act not just for the shareholders, or even to go further than 172 and to have it for all stakeholders, is, I think, a step too far. And that's why in our model we are proposing other ways to assist the stakeholders, like engagement, providing them with information. Of course, corporate purpose is relevant in this regard as well. And maybe also a final point is to remember that stakeholders have potentially a lot of protection elsewhere as well. Employees have labor law, consumers, consumer protection, but shareholders really only have company law to protect them in a way. So that's perhaps another argument to make in this context.
I think that we have still time for maybe one more question. We are more or less... Yes? Thank you very much.
Thank you. And thank you so much for in fact, like a lecture for me. Thank you to all the three members of the panel. I would like to ask, and related to this, to stakeholders protection, I have a question regarding the legitimacy that stakeholders may have, particularly in Companies Act or in British and UK company law, regarding the protection that shareholders could have against, or some legitimacy they have or could have against the decisions made in the board. I mean, recently, we have some European, particularly recently in France, the law has changed and introduced this enlightened corporate interest, and a lot of people is, in fact, worried in a kind of way regarding the decisions that the board could make, and if the stakeholders would have, like the workforce and even some third persons, if they could have some legitimacy to claim against the decisions made by the board regarding, business decisions. Thank you.
Okay, I can try to answer that, and Iain, please just add if there's anything else. So I think your question, if I understand you correctly, deals with basically the enforcement of Section 172. So in other words, Section 172, of course, lists all of those stakeholders. So it is one of the director's duties to consider the interests of those stakeholders when they make business decisions. But ultimately, the decision must still be in the best interest of the shareholders. So It is a step further than pure shareholder primacy because they have to consider their interests, but it does not go as far as the pluralist approach where there is direct protection for all stakeholders and where shareholders and stakeholders, other than shareholders, are on the same level. So perhaps you can say that Section 172 provides a right to stakeholders to be considered, but that's all. It's within the subjective discretion of the directors to what an extent they consider their interests. But there's no specific enforcement. The only way that they can enforce it is if they can show that they did not consider their interests. But I mean, that's almost impossible because it's a subjective discretion. So there's not a lot of case law on Section 172 in that context. Most of the case law is where they refer to Section 172 as one of the factors that you have to take into account for derivative actions. So there you will find case law, but not with regards to a breach of 172 from a stakeholder.
And now we have to conclude, because we have a very interesting panel. Then you, all attendants, deserve, and of course our speakers deserve a round of applause. Thank you very much.